Good evening, everyone. My name is Susan Coleman. I'm the president of the New York City Bar and a partner at Jenner & Block. It is my great pleasure to welcome you to tonight's program, The U.S. Territories, Separate and Unequal. I want to particularly take a moment and thank Wanda Sanchez-Day, as co-chair of the New York City Bar's Puerto Rico Task Force, and Myrna Santiago and Professor Natalie Gomez-Velez, co-chairs of the New York State Bar Association's Task Force on the U.S. Territories. Our program chairs, the three of them are our program chairs, and they, as you are about to see, have put together an absolutely terrific program for us this evening. Following the end of the Spanish-American War in 1898, the U.S. Supreme Court considered the extent to which the U.S. Constitution applied to residents of its territories in the so-called Insular Cases. Tonight, we will revisit the current status of the United States and its territories 125 years later. As we will hear, the U.S. territories remain subordinate to federal rule today in many of the ways that they did then. Remarkably, the Department of Justice has defended a sweeping view of federal power over people in U.S. territories with no clear limits and repeatedly relied on the Insular Cases and even actively discouraged the Supreme Court from reconsidering those cases. After this incredible program, hopefully, we will all be armed to push for much, much needed change 125 years later. And with that, I'm going to ask Sherry Wallach to come up.
Thank you, Susan, and good evening, everybody. My name is Sherry Levin Wallach, and I'm the immediate past president of the New York State Bar Association. And I, along with Susan, thank our program chairs and the planning committee for putting together this outstanding program. And I also want to thank the New York City Bar Association for collaborating together with the New York State Bar Association on these really important issues. It shows how, when groups get together, we are stronger. So thank you for that. So I welcome everybody, and I'm really going to start off by saying it's great to be here amongst what I like to consider my territories family, my U.S. territories family, because this group has been working individually and together with many other groups for a long time to right the wrongs that were created by the Insular Cases and the Territories Clause. Before I get into the rest of my remarks, I must stop and recognize Judge Jenny Rivera, who is our Court of Appeals Senior Associate Justice. She sends her regards. She is a member of the New York State Bar Association's task force, and fortunately, I guess we should say, she is a keynote speaker this evening at an event just down the road, and so she sends her regards and regrets for not being able to be here. Had that not been the case, she would be here. I also want to send my apologies because I must step out early because I have to introduce her. That said, let me say this. When I was preparing to become president of the New York State Bar Association, and I was designated as the president-elect designee, as they say, I was speaking with my good friend and longtime colleague, Representative Stacey Plaskett, about some of the issues that were concerning to her in the Virgin Islands. And that is how this issue was brought not only to my attention, but to the attention and the action of the New York State Bar Association. So we went to our Diversity, Equity, and Inclusion Committee, and I spent the next couple years providing CLE programs like the one we're going to have this evening, raising awareness and educating those of us in the legal community and beyond the legal community on the issues that have faced the U.S. territories since the early 1900s and the development of the Territories Clause. And suffice it to say that what it leads to, in the end, is unequal treatment of the people who are citizens of the United States but live in the U.S. territories. You're going to hear more about that tonight. But what I like to start off with, and what I find many people don't realize, is if any of you, not having born or been a descendant of somebody from a U.S. territory, decides you want to move to a U.S. territory, you lose your right to vote, you lose your right to collect SSI, and I will go on, but I will leave that for my colleagues as to some of the other rights that you lose and limitations that you have on the rights that are given to American citizens under the U.S. Constitution. So when I took office as the New York State Bar Association's president, I established the task force on the U.S. territories, co-chaired by Natalie Gomez-Velez and Mirna Santiago, and vice-chaired by Anthony Scioli, who I think is joining us by Zoom this evening, a longtime activist and past president of the Virgin Islands Bar Association. We worked together to collaborate with the Virgin Islands Bar Association, the Colegio de Abogados y Abogadas de Puerto Rico, as well as the Guam Bar Association, to really move these issues forward. And of course, we wouldn't have been the same and would never be the same without working with our good friend Neil Ware and the Right to Democracy. He's now brought on Adi to his team, and really the work that we've all done together, and thanking them for being members of the task force as well. So after our defeat, and I will call it our defeat, although I think Neil takes it very personally, where the U.S. Supreme Court denies certiorari in the Fitzsimonu case, we are now positioned in a different place, but more than ever, to raise these issues. And the question that we were just discussing, is this something to bring back to the United States Supreme Court? Is this something for our U.S. legislature? Is this something for both? And I think those questions will be discussed and answered later this evening. But at the New York State Bar Association, we worked very hard to position ourselves to be able to file an amici in that case or any case that was coming after it, to enforce and hope to support the overruling of the Insular Cases and their racist underpinnings. We, as associations, as lawyers, and as communities, can never truly raise beyond the racist underpinnings that lay within our society and the creation of the U.S. society until these cases are overruled, until we move beyond the language that is in these cases that allows people to refer to as good law things that are truly discriminatory and create further discrimination in our societies and communities. So I believe, and I think many of us here tonight believe, and I hope you all here when you leave will also believe, that it is of the utmost importance that we continue our work to have the Insular Cases overruled, to ask DOJ and the Biden administration to denounce these cases and their jurisprudence, and that we continue the efforts for the equal rights of the people of the U.S. territories. As you will hear throughout the evening, the question of whether this is an equal protection question is one that has been wrestled with by our Supreme Court and by our litigants. And we will explore that in addition to many other questions this evening that surround these issues. So I thank you all for joining us. Again, I thank the panelists, and I am thrilled to continue to work together with all of you on moving these issues forward. Thank you.
Good afternoon. My name is Wanda Sanchez-Day, and I think I'm going to just take about 2 seconds to introduce the New York City Bar Association's Puerto Rico Task Force, who is working with the New York State Bar Association's Task Force on the Territories. We're very happy to see you here today. You will learn a lot hopefully about the U.S. territories. I know that this is a mixed crowd here. Let me just tell you a little bit about the Puerto Rico Task Force and welcome you to join the Puerto Rico Task Force at any point. We are looking for members, always, to sort of maybe bring attention and education to everyone about the U.S. territories. And we focus mostly on Puerto Rico, and there's a reason for that. In 2016, the New York City Bar Association created the Puerto Rico Task Force to deal with what we all know as Promesa, which is the bankruptcy that Puerto Rico underwent since 2000, I believe, 14 or 15. The task force has been tackling those issues since through various chairs. My co-chair, Carlos Morales, who is sitting before us here, and I have, in a way, taken on opportunity to bring more attention to this issue, and the result is the collaboration with the New York State Bar and Rights to Democracy. The task force also has the task of, as we see it, of looking at the human rights and the civil rights issues occurring in Puerto Rico. So hopefully you'll hear a lot about that tonight from our distinguished panelists, who include Neil Weir, who is the co-founder and co-director of Right to Democracy, which works to confront and dismantle the undemocratic colonial framework that governs the U.S. territories. He is guided by the belief that there should be no colonies or second-class citizens in the United States. As a civil rights attorney, he has litigated landmark cases, arguing to overrule the Insular Cases, which you'll hear more about today. He argues for the advancement of equal citizenship, voting rights, and federal benefits equally in the United States territories. Prior to attending Yale Law School, he worked for Guam's non-voting delegate to the U.S. House of Representatives. He is the co-author in the forthcoming case book, Law of U.S. Territories, which he has taught at Yale, Columbia Law School, and he represented Guam in the 2004 Athens Olympics. We have also with us Professor Christina Ponce-Krauss, who joined the faculty of Columbia Law School in 2007. She is a George Wellwood Murray Professor of Legal History. A Puerto Rican raised on the island, she writes about constitutional history of the American territorial expansion and the extraterritorial application of the U.S. Constitution, examining their implications for American federalism, citizenship, and nationhood. We also have Professor Emmanuel Iram Arnud, an assistant professor of law at Cardoso Law School. He is previously a visiting assistant professor at Cornell Law School, where he taught criminal law and a seminar on U.S. territories. His research focuses on the application of federal criminal law and procedure in the U.S. territories. On this, we have Professor Natalie Gomez-Velez, who is a professor of law at the City University School of Law. Professor Gomez-Velez teaches public institutions, administrative law, and constitutional structures, among other courses. She has served as CUNY's Law School's Associate Dean for Academic Affairs from 2007 to 2010. We also have, on the screen, we hope, Anthony Cioli, who is Vice President of the New York State Bar Association's Task Force on the U.S. Territories. He is a past president of the Virgin Islands Bar Association and served as senior clerk and special assistant to the chief judge of the Virgin Islands. And lastly, but not least, we have Manuel del Valle, who will join us also via Zoom. He is an adjunct professor of law at the International American Law School, where he teaches in Puerto Rico, where he teaches courses on federal trial of advocacy, litigation, theory, doctrine and practice, and federal motion practice advocacy, mediation, and arbitration practice advocacy. We also have with us Mirna Santiago, who is the co-chair of the New York State Bar Association's Task Force on the Territories. And we have with us Jason Canales, who is the current president-elect of the Puerto Rican Bar Association, who has gracefully agreed to co-sponsor this event. We have another co-sponsor, which is the OLA, which is the Organización Latinoamericana of Eastern Long Island, and I am the general counsel and senior policy counsel with OLA, and and we also have one other. Who is our other? Anyway, if I forgot someone, I'm very sorry, but we're going to move ahead. We have a very full program, and thank you for being here. Thank you.
Okay, good evening. Again, thank you all for attending tonight's program, U.S. Territories, Separate and Unequal. As was mentioned, my name is Natalie Gomez-Velez. I'm a professor of Law and co-chair of the New York State Bar Association's Task Force on the U.S. Territories. And I got to say, it's truly a pleasure to be with you all on this very warm evening in this very cool space to discuss the separate, unequal, and unacceptable, frankly, treatment of the U.S. territories. So at a moment when concerns about democracy, sovereignty, the rule of law, equity, equal protection are front of mind in the United States and around the world, it is critically important to raise awareness and work to address the United States' own colonies problem and the separate, unequal, and again, unacceptable treatment it imposes on the U.S. territories. But before we begin, I have a couple of questions. I wanted to ask you a couple of questions because I like to get a sense of where we are with the audience. How many of you are familiar with or from any of the U.S. territories? And I'll say what the U.S. territories are. How many familiar with or from? Okay. How many of you are not familiar with or from any of the U.S. territories? Oh, whoa. Anybody else? So we got about half and half, it looks like, right? Am I counting right? How many of you are familiar with the Insular Cases and or current Supreme Court treatment of the Territory Clause of the U.S. Constitution? Are familiar with it? With those cases, the Insular Cases and the current treatment. Who are not? How about how many are not familiar? Okay, so I think we pitched this right? Because we have a combination of just an overview. So I'm going to provide an overview. There may be a little bit of repetition in my overview and some of the panelists, but we'll try to minimize that. And I ask because we have found that the territories are often treated as invisible, right? If you envision in your mind the map of the United States, right, what some have called the logo map of the United States, what comes to mind? There's that map with the shape, right? And then you got maybe you'll have Alaska and Hawaii, right? But you don't see on that map often are the territories, right? We really don't have them kind of in public consciousness in the United States in the way that we have the other states, et cetera. Also, consider also the notion of colonialism when we talk about colonialism, right? As I was preparing for this, I Googled the word U.S. colonies, the phrase U.S. colonies, to see what I would find. I found that the top entries tend to address the first 13 colonies, right, on a time period from about 1775 to 1781, and that's about it. And you see the picture of the 13 colonies and the discussion about that. To be fair, there were a few references to territories that came up, but mostly that was the discussion. So I have to say it is understandable, if unacceptable, that many in the U.S., including well-educated lawyers, are unaware of the status and plight of the U.S. territories. So the United States includes 5 populated territories. I had a map, but we're not going to do that. American Samoa, right? Guam, the Northern Mariana Islands, the U.S. Virgin Islands, and Puerto Rico, which is the largest and most populous of the territories, but there are 5 territories that are in the same status. The United States has held some of these territories in subordinated, essentially colonial status for 125 years. This means that U.S. territories, which are neither states nor independent sovereigns, are held in an ambiguous, separate, and unequal limbo status and have been so for more than a century. And that status has real constitutional and practical implications for, among other things, the right to vote for president, representation in Congress, sovereignty, self-governance, equal protection, economic self-determination, a whole range of both legal and practical issues, right? Not to mention just basic human dignity. The claimed authority for such treatment is an interpretation of the Territorial Clause of the United States Constitution that includes the notorious and judicially invented distinction between incorporated and unincorporated territories. And that distinction was under what is known as the Territorial Incorporation Doctrine, was established under the Insular Cases. Now, I have stuff here that's kind of going through some of the discussion of the insular cases in my overview, as well as the territory clause of the United States Constitution. But I do think that that will be covered, and I really do want to get us to our panelists. So I'm going to go forward in my remarks and note a couple of things. One, the insular cases, right, which came into play in the early 1900s, what we're talking about 125 years, more than a century and a quarter of these cases, remain good law in the United States and established, they were around the time of Plessy versus Ferguson. So when we talk about separate and unequal, that's the time period we're talking about, and we're talking about cases that invented unincorporated, certain unincorporated state territories on a blatantly racist basis. Because before that, territories, if you think the Northwest Territories, other territories, were considered to be part of the United States and under constitutional provisions, right? And so the insular cases remain so-called good law today, and they allow the continued arbitrary and unequal treatment of the territories and their residents. But worse yet, recently, the Supreme Court, given several opportunities to finally overrule the insular cases, not only has failed to overrule them, but the court, in my opinion, and we're going to talk about this a little bit, has arguably made things worse. So much so that several scholars and advocates now dub the recent series of cases involving the U.S. territories the new insular cases. So the endurance of the insular cases under current law, to our view, many of our view, is an affront to core constitutional notions of equal protection, representative democracy, and fair treatment, as well as to basic principles, again, of human dignity and self-determination. And while the Supreme Court has explicitly overruled or cabined other cases rooted in racism and a national conception, self-conception deemed intolerable today, consider recently the statement about Korematsu in United States v. Trump, in Korematsu v. United States in Trump v. Hawaii, the insular cases, again, remain good law on the books. And as was mentioned earlier, are being cited, are being used in ways that are concerning. And several members of the court certainly know this. As Justice Gorsuch explained in a concurrence in the case U.S. v. Valle Madero, which is one of the cases we'll be discussing today, he said, "A century ago, in the insular cases, this court held that the federal government could rule Puerto Rico and other territories largely without regard to the Constitution. It is past time to acknowledge the gravity of this error and admit what we know to be true. The insular cases have no foundation in the Constitution and rest instead on racial stereotypes. They deserve no place in our law." I don't tend to be someone that agrees with Justice Gorsuch on everything, just saying. However, we are in agreement on that point. And I have to say, not only has the court repeatedly declined to overrule the insular cases, as in Fittisemano and other examples, it appears to be shifting the doctrinal bases for maintaining the colonial subordinated status of U.S. territories under the territorial clause and other constitutional doctrines, as our esteemed panel of expert scholars and advocates will explain. They will walk us through the constitutional context, right, that background, the new insular cases, and real-life implications for the people of Puerto Rico and the territories. The discussion will then move beyond the Supreme Court to talk about the implications for residents of the territories and what can be done. For example, what can the political branches, as was mentioned, Congress and the executive, do to address the separate and unequal treatment of U.S. territories and their residents? And what can we do to persuade them to act? So along that line, again, I'm just going to turn it over. We are so pleased to have, after that, the esteemed bar leaders will have a fireside chat to talk about that. But at this moment, let's turn to our impressive panel. You've heard their bios. You have them in your material. And so we will start with Professor Cristina Ponsa-Kraus, distinguished professor at Columbia School of Law, who will explain the constitutional context surrounding and affecting the U.S. territories. Professor Ponsa-Kraus.
Thank you all for being here. Thank you for the introduction. My job is to explain those insular cases that you keep hearing about. The territories can't be reduced to the insular cases. There's so much more. And yet, at every turn, one finds that they are relevant, they are looming, the court itself has called them a dark cloud hovering over one case in particular, but really the constitutional world in which the territories exist. So what are these insular cases? And the question that might arise for people with even a sort of a passing knowledge of American territorial expansion right away is, what happened in 1898 to 1901? The U.S. had territories before. There were Northwest territories, there were Southwest territories. The United States started out, a little group of colonies on the coastline. So territories weren't anything new in 1901 when the first insular cases were decided. The Constitution has a territory clause, as was referred to. The territory clause gives Congress the power to, it says, dispose of, Congress shall have the power to dispose of and enact all needful rules and regulations respecting the territory and other property of the United States. And then it goes on. That basic language has been understood to empower Congress to create territorial governments, which is something Congress did from the beginning. So the difference between states and territories at a very basic level was that every state had its own government created under its own state constitution and then existing in a semi-sovereign status underneath a supreme federal government. And then there were territories. Congress was in charge of creating the governments for territories and then, running things there, although Congress would appoint officials and, delegate governance to territorial governments. So from the beginning, the territories did not have representation in Congress. Territorial inhabitants never voted in presidential elections. Territories have been colonies from the beginning. However, the received understanding, the shared understanding about territories in the United States was that they were transitional jurisdictions. Territories were on their way to becoming states. That's what the territories were. That's what everybody assumed about them. For that reason, they were thought of as part of the United States. Really, the question whether they were part of the United States or not came up, indirectly in one case before the court, but, and the court said, of course they are. That was the answer. And that was that. And so they had their second-class colonial status, but that was a transitional status on the way to statehood. So what happens in the 1898 to the turn of the 20th century, 1898 is the war known as the Spanish-American War, which is really the Cuban War of Independence against Spain. The United States intervenes in that war in 1898. It had already been raging for 3 years at that point. The United States promised that it was not going to take sovereignty over Cuba. It was just intervening to help liberate Cuba, was the idea. But once the United States joined Cuba and defeated Spain in the treaty negotiations with Spain, Spain ceded sovereignty over Puerto Rico, the Philippines, and Guam. So the United States occupied Cuba but didn't take sovereignty over it. But lo and behold, it took sovereignty over Puerto Rico, the Philippines, and Guam. And these events gave rise to a nationwide debate about what to do with these new territories. And so then the question is, well, why debate? We always do the same thing with territories. We annex them, we put them on this transitional path, and then we make them states. But this was a period of sort of imperialist enthusiasm. The United States had been an empire from the beginning for sure, expanding westward, displacing and killing Native Americans, taking territory, et cetera. But at this moment in history, officials of the federal government and the public were interested in the possibility of the United States having colonies sort of European style. The debate was, can we take places and not make them states? Can we just keep them as colonies and govern them as colonies and maybe even get rid of them. That's something that in my scholarship I have focused on, something that also had not been on the table for prior territories. So this debate is raging in the newspapers and what have you, and in the law reviews. Lawyers got involved. And the way that lawyers talked about it was largely, the question was, does the Constitution follow the flag to these territories? It always has followed the flag to prior territories. There were debates in the 19th century about exactly how the Constitution followed the flag, but the received understanding was basically it does. So then the question became, does it follow the flag to these new territories? That was, in popular parlance, that was the debate. The Supreme Court weighed in the Insular Cases, but before I talk about those decisions specifically, I want to say there were answers to this question proliferating not only in debate, but in authoritative legal texts, like, for example, the Treaty of Peace with Spain, in the provision that in the past, when the United States had annexed territories, there was always a provision in a treaty of annexation that said the inhabitants of the territories shall be made citizens as soon as possible. The language varied, but basically it was they shall be made citizens and incorporated into the rights and privileges of citizenship as soon as possible. The Treaty of Peace with Spain said that Congress would determine the civil rights and political status of the inhabitants of the new territories. So sort of open question, we'll let Congress figure it out. And I want to point that out now because I want to emphasize throughout that really one central core harm of the Insular Cases and the constitutional framework for the new territories that they created is the sort of lack of answers, the ambiguity, the confusion, all in the service of increased federal power and discretion and control. So it's just kick the can, kick the can, kick the can. Answer this little question, but this constitutional provision applies, but we're not going to say what else applies. These people have been annexed, but we're not going to say if they're citizens. At every step, it's ambiguity, confusion, ambiguity, confusion. So you have Congress shall decide this question, and then in the statute creating Puerto Rico's government, these statutes that create territorial governments are known as organic acts. So in the statute creating Puerto Rico's government, the Foraker Act, Congress declined to confer citizenship or extend the Constitution, which it had done in statutes creating governments in prior territories. Congress doesn't really need to extend the Constitution. It either applies or it doesn't. But in this case, Congress withheld language that sort of confirmed that these places are now part of the United States, and of course the Constitution applies there. So Congress also sort of left Puerto Ricans and Filipinos and the people of Guam in this sort of uncertain place. Then the Supreme Court comes in. In the Insular Cases of 1901, the Insular Cases, there are various lists, and we've got the new ones, and et cetera, but the core and the leading Insular case decided in 1901 was Downs versus Bidwell. And Downs versus Bidwell was about what sounds like a sort of technical debate about the uniformity clause. So the Constitution's uniformity clause requires that all duties, imposts, and excises be uniform throughout the United States. So what happens in 1901 is that a challenge comes to the Supreme Court, a challenge to duties imposed on goods, specifically oranges in this case, being shipped from Puerto Rico to New York. So the relevant litigants challenged these duties, saying that they violated the uniformity clause to impose duties on goods coming from Puerto Rico to New York within the United States. Just these goods violates the uniformity clause was the challenge. So the uniformity clause, I just quoted, refers to the United States. So the question in Downs versus Bidwell was, is Puerto Rico, and by implication the Philippines and Guam, are these new territories part of the United States for purposes of the uniformity clause? That, in popular debate, turns into, are these places part of the United States? Are they part of us? The Supreme Court answers that question in the negative. It says the uniformity clause does not apply there. Congress can impose these duties without violating the Constitution. And in the popular debate, this is received as they're not a part of us. They're not a part of the United States. And yet, in another insular case, De Lima v. Bidwell, the court had held that these places weren't foreign either. So suddenly we've got not foreign, not part of the United States. What are they? So the most important opinion in Downs versus Bidwell was a concurrence by Justice White, who was joined by 2 other justices. He said that the new territories were foreign to the United States in a domestic sense. So some of you have heard that phrase. Those of you who have never heard that phrase and are thinking, what on earth does that mean? Some of us who have heard that phrase many times still aren't sure. The dissenters in Downs had no idea what the concurrence was talking about. What is this? It was a way of, having your cake and eating it too, creating ambiguity. More than anything else, it was a way of communicating the message, we own you. You're not really a part of us, but we own you. You are colonies of the U.S., and we'll figure out what to do with you as time goes on. That's a paraphrase, but that language was in the concurrence, foreign to the United States in a domestic sense. So that phrase stands in for reasoning in Justice White's concurrence, where he said, basically, there's a difference between annexing a territory and incorporating it into the United States. And that's the doctrine that is associated with Downs versus Bidwell and the rest of the insular cases, but really the place where it's articulated is Downs versus Bidwell. It's this separation between annexation and incorporation, and so it's known as the doctrine of territorial incorporation. And what it stands for, what it means, is that there are territories, was what Justice White explained, that have been annexed by the United States but not incorporated into it. So they belong to the United States but aren't a part of the United States. They are foreign to the United States in a domestic sense. The uniformity clause doesn't apply, but other constitutional provisions surely do, but we don't know which ones. We'll figure it out on a case-by-case basis. That's Downs. That's the insular cases. So what happens, when did I start? I'm good, okay. All right, so what happens next? So you've got De Lima saying they're not foreign, Downs saying they're not part of the United States, so they are, domestic but sort of foreign. There was actually a line like that too in Downs. They are domestic in an international sense and foreign in a domestic sense. This guy, was clearly getting paid by the word. So message what? So the uniformity, on the facts, the holding is the uniformity clause doesn't prevent Congress from imposing these duties. The message was, you all are in sort of a constitutional vacuum-ish, although definitely some constitutional provisions apply. We all agree on that. And the second part of the message was, you're not on the way to statehood. We could keep you this way forever. I've argued in my scholarship that the message was also, we could get rid of you. We could grant you independence, but we decide, we being Congress, the federal government. Why? Racism. So you've already heard it alluded to. This is the era of Plessy v. Ferguson. It would be nice to say this is, way back then when the United States was racist, and yet it keeps kind of bubbling up. But at this point in time, it was explicit. It was just, the way white people talked and thought. It was the era of not only Plessy and segregation, it was the era of the Chinese Exclusion Acts, which barred Chinese immigration into the United States. It was the era of racial limitations on naturalization. It was, just a very racist time. And so that racism informed the insular cases too. And so in the language of the cases and in the language of the public debate, these people are, too foreign, too different. We can't really let them participate in the halls of governance. We can't let them ever vote or be represented. The court alluded to them as savages. We can't, give citizenship to people to these, alien races, et cetera. So racist language and a racist time to justify what in the end was a new category of territory. Okay, we've always had them, but these could be territories forever. Ambiguity, confusion, limbo, but subordination for sure. That we know. And then case by case, we'll figure out what applies. As you will hear, over time, a lot has applied. When the Supreme Court has looked at which constitutional provisions apply in the territories, often, almost always, it has applied rights. But it has never changed the proposition that the territories can remain territories deprived of representation and deprived of sovereignty forever. To me, that is the absolute heart of the matter. Lack of equality, lack of representation, lack of a voice, and also not your own sovereignty, and not the equal semi-sovereignty of a state, just subordinate limbo. So the fact that they throw us a bone by applying a constitutional provision here and there, I mean, you know, rights matter, I don't deny that, but the problem remains intact. So I have a couple, two more insular cases there's a long series, but I'll just go to two more key cases and then I will wrap it up. So a few years after Downs, the court did to the people of the territories what it had done to the territory. It created an ambiguous limbo subordinate status for them. So the inhabitants of these territories had not been granted citizenship. A case arose when a woman traveling from Puerto Rico to New York was detained at Ellis Island and not admitted. She was held to be inadmissible on the ground that she was likely to become a so-called public charge. I say so-called, it's still in the law, but this idea that you can't support yourself, and so we are not going to admit you. And she sought habeas, arguing that she was a U.S. citizen and they didn't even have a right to detain or examine her, let alone exclude her. And her case went to the court, and the court did a dodge. It said, under the current immigration laws, she is not an alien, so she cannot be detained or excluded. But we're not going to reach the question of whether she's a U.S. citizen or not. We're going to leave the question everybody thinks is the question in this case, which is, are they citizens or not? We're not going to say. All we can say is that she's American. Puerto Rico's been annexed, so she's American, but, said the court, you can be an American but not be a citizen, creating what is now has been since then known as the category of the U.S. national, non-citizen U.S. national. I'm sure you'll hear more about that category from other panelists. So now we have ambiguous, confusing, but subordinate territorial status, and ambiguous, confusing, but subordinate personal status, because at this point, inhabitants of the territories could travel back and forth, but they didn't have all the rights that citizens had when they were in the United States, because as you know, an audience like this knows, most rights of citizenship come from statutes, not directly from the Constitution. So in 1917, Congress made the people of Puerto Rico citizens. It would happen later for other territories and not for all. But I mention the 1917 grant of citizenship because several years after that, we get to the third case of the three that I'm going to mention. Balzac versus Puerto Rico, 1922 case. It concerned the right to a trial by jury. The question was, does the right to a trial by jury apply in Puerto Rico in a local court in Puerto Rico? The answer was no. It's an interesting case just because, as I've written about in my scholarship, at this time, the federal right to a trial by jury didn't apply in states either. So Puerto Rico wasn't really being treated differently from states in the upshot, although the reasoning was all about these foreign and a domestic sense places, and Puerto Rico hasn't been incorporated, and so some provisions apply and some don't. All this exceptionalism to maintain the subordinate status. But the more important point in Balzac was that the court made clear that even after the grant of citizenship, Puerto Rico was still not incorporated into the United States. Puerto Rico was still what we now know as unincorporated. So the 5 territories of the U.S. today are unincorporated territories belonging to, but not a part of, the United States. So what Balzac said was citizenship didn't make a difference. That was very much in tension with a lot of language in Justice White's concurrence in Downs. He definitely thought that citizenship would mean incorporation. At this point, the court endorsed his concurrence but rejected that language and said citizenship does not actually incorporate. So I am going to wrap it up by saying the Insular Cases have been described as central documents in the history of American racism. That's a quote, that's one constitutional scholar, but many scholars have made this point in many ways. And so the mystery remains, why are these cases still good law? And so you're going to hear a lot about why these cases are still good law and shouldn't be from my fellow panelists. I will leave you with the thought that these cases serve the interests of the federal government in maintaining maximum discretion, power, and flexibility in the territories. And so, again and again, I say the fact that the territories have been granted certain things, for example, Puerto Rico has been granted a certain level of autonomy, doesn't change the fact that it remains subject to this constitutional framework, which empowers Congress both to keep it that way and to take some of that autonomy away, as it did with PROMESA and the creation of the board that Congress empowered essentially to oversee the Puerto Rican government. So there are arguments that have been made recently that maybe these cases could be reconceived and repurposed and sort of, reinterpreted toward the end of self-determination in the territories. And my bottom line will always be these cases are about empowering the federal government, not the territories. And what the territories need for their empowerment, in my opinion, is either, their own full sovereignty or representation in the federal government. They need equality, voting rights, and the dignity that comes from not being a colony. So I will leave it there. Thank you.
Thank you. So Neil, we're going to turn to Neil Ware, founding director of Right to Democracy, who's going to bring that up to the present and talk about some of the new insular cases.
Thank you. Thank you, Susan, Wanda, and Sherry, Miriam, and Natalie for organizing this great event today, and Christina for setting up that historical context. And I think it's the perfect transition to what I want to talk about this evening, which is a series of new Supreme Court cases decided over the last 5 to 7 years, where this thread that Christina talks about maximum discretion and power for the federal government over the territories really continues to strengthen and grow, as opposed to having some reconsideration about this legal, undemocratic colonial relationship between the United States and the 3.6 million people who live in U.S. territories. So I'll talk through each of these cases, give you a little bit of a framework of what the questions presented were. I'll reframe them a little bit to be a little more pointed than the actual questions in the case, and then also talk a little bit about what positions the U.S. Department of Justice took in each of these cases and how this question of the insular cases and its continuing relevance today came up in these cases. So I'm going to start with the most recent of these cases, which involved this federal oversight board that has been raised a few times, that has basically serves as a super government over the government of Puerto Rico, has control over anything related to finances in Puerto Rico, which essentially is everything. You can always draw a connection to how does this impact a place's finances. In this case, Federal Oversight and Management Board versus CPI, which is a Puerto Rican nonprofit journalistic organization that had sought from this board information pursuant to Puerto Rico's constitutionally protected freedom of information laws. So after the board was created, CPI said, hey, we'd like to get these documents that the Puerto Rico Constitution actually gives us a right to receive. When the board was not responsive to that, they took them to court, as is often the case for these kinds of document requests. And this overall law, PROMESA, restricted where you could sue the board. So they couldn't take them to court in Puerto Rican courts, which would normally be the case for this kind of Freedom of Information Act request. If it was in New York, you could take the New York government to court here in the New York courts. Instead, you had to take them to court in federal court. And so that's where CPI sued. But the board then made what, in my view, is a very kind of brash argument that you can't sue us because we're protected under 11th Amendment sovereign immunity. And so the question presented to the Supreme Court in this case was, can the Oversight Board defend against a suit seeking public documents under Puerto Rico's Freedom of Information laws by invoking 11th Amendment sovereign immunity, importantly, without first establishing that 11th Amendment sovereign immunity even exists? And so the court and the discussion and the posture of the case when it came to the court was that they only took up the secondary, and the court did not take up the foundational question of, did sovereign immunity even exist? And this is something you see with a lot of these territories cases, is just this kind of really odd posture, approach, strange ways of analyzing the laws that often seem to have some really kind of results-oriented implications. So this kind of odd, very odd posture addressing the secondary question while not addressing the underlying question came up from Justice Kagan, who called it quite weird. And the board's counsel said they were not able to find a case where the court had ever done this before, addressing that secondary question without addressing the underlying question first. So this is something that Justice Thomas called out strongly in his dissent, and this was an 8-1 case with only Justice Thomas dissenting. He said, CPI might be forgiven for wondering whether we granted certiorari only insofar as our review would favor the board. He said the result of the case with the board, or with the Supreme Court saying that that sovereign immunity hadn't been waived without addressing the underlying question, effectively consigned CPI's case to the dustbin. And he emphasized, I think the court has a duty to pass upon issues that are fairly presented, preserved by the parties, and necessary to support its judgment. So this is an odd case in other ways as well. I was very surprised when the court first took it up. You had no circuit split on these issues, so there was no reason there. It was an interlocutory appeal, which oftentimes the court disfavors taking up. And again, this underlying question of sovereign immunity had not been addressed and resolved by the lower courts. Again, another reason why this kind of case might be unlikely to be taken up by the Supreme Court. Nonetheless, the result was that this journalistic enterprise and other people in Puerto Rico are basically prohibited from obtaining freedom of information documents, basic documents about what the board does and how it's acting, even as this board is imposed by the federal government, undemocratic in that it has no democratic accountability to the people of Puerto Rico, and essentially has full powers of government, being able to veto local laws based upon the financial implications. They've dramatically reformed the pension system in Puerto Rico. Recently, the university, this semester actually, the university had shut down over disputes over labor disputes until the board finally came in and said, okay, we'll agree to these parts, we won't agree to these other parts. So it's this incredibly undemocratic situation to begin with, and then here you have the court stepping in to prevent the people of Puerto Rico from being able to obtain the kind of public information that could help hold this kind of board accountable. And this kind of decision-making is something that, again, is all too common in federal courts in general, but before the Supreme Court in particular, where it feels like a kind of heads I win, tails you lose doctrine. When something favors maximum discretion or federal power, the court is almost sure to rule in that favor. When maybe a similar idea might favor the territories over the federal government, then that's not for the courts to weigh into or resolve. We'll have some judicial discretion there. So that's the CPI case. I'll just go chronologically through the other cases that are part of this so-called new Insular Cases. The first of these was a very interesting case that my colleague here will talk more about, Puerto Rico versus Sanchez Valle, which asked, do criminal defendants in Puerto Rico enjoy the protections of double jeopardy when prosecuted for the same offense under both federal and Puerto Rican law as they would if they lived in a state or federal Indian reservation? So for those of you familiar or unfamiliar with double jeopardy, someone commits a crime in New York, the federal government can prosecute them. The state of New York can also prosecute them for that same crime. But if someone is prosecuted in New York, another New York prosecutor can't come and prosecute them for the same crime. That's the way double jeopardy works, but not in the territories, because, as the Supreme Court ruled, U.S. territories do not have any sovereignty separate from the United States. And this ended up being a real watershed moment for questions around Puerto Rico's relationship with the United States, as Christina has written about quite extensively, and as some of you may be familiar with, there was this idea in Puerto Rico around the Commonwealth status, also known as ELA, Estado Libre Asociado, which created this idea that there was some sort of semi-sovereignty or autonomy separate and apart from the United States. And the Supreme Court in the Sanchez Valle case went through point by point, basically making clear that from the top to the bottom, it's U.S. sovereignty all the way. Puerto Rico's constitution, the law that created ELA, changed none of that. Full U.S. sovereignty from top to bottom. Just a week after the Supreme Court issued that decision, I had the first of my petitions before the Supreme Court calling on them to reconsider and overrule the Insular Cases in a case Tua'ua versus United States, which considered whether, with this recognition of sovereignty, there came certain protections to the people who lived in these areas, including a recognition of a right to citizenship. That case was denied a week after the Supreme Court said that it's sovereignty top to bottom. And then that same time period is when the PROMESA law was actually passed by Congress and signed into law by President Barack Obama. And so you have this kind of moment where there's this new attention to issues in the territories from the Supreme Court, from the President, from Congress. And again, the takeaway is maximum discretion, maximum federal power. So then the next case that was decided, again, just a little bit after that one, this case called the California Franklin Trust case, looked at, well, what kind of discretion or power remains in Puerto Rico, even under this broad framework. So the question was, does Puerto Rico have the power to enact its own bankruptcy laws when federal bankruptcy provisions have arbitrarily excluded them? So the history of this case and some of the context around Puerto Rico's financial troubles is there was a federal law that provides for bankruptcy provisions throughout the United States, including municipal entities. Inexplicably, and despite probably billions of dollars of lawyer fees investigating this question, there's no idea of how Puerto Rico was excluded from that bankruptcy law. Inexplicably, they were there one day, they weren't there the next, no one knows why. And this created a very significant problem when Puerto Rico's finances became really acute and it began facing the severe debt crisis of over $70 billion. And in the absence of federal legislation creating a framework for bankruptcy in Puerto Rico's government was left to act for itself, and the legislature passed a law to create a bankruptcy framework so that it could go through this process of bankruptcy in a more orderly and sensible fashion. And the Supreme Court, 5-2, said, no, Puerto Rico, you don't have the power to do that. This law is preempted. Federal law preempts Puerto Rico from legislating in this space, no matter the fiscal crisis. And this is really what led kind of to the crisis that then created PROMESA and what followed from there. Another important case, again, dealing with some of these same questions around the board and its powers, is this case Aurelius versus the Federal Oversight and Management Board. And this is a case where the question presented was, are officials appointed by the President of the United States who serve on an unelected, federally imposed oversight board in Puerto Rico officers of the United States who require the advice and consent of the U.S. Senate? And what the Supreme Court ruled in this case was no, they are local officers with primarily local duties. So the creation and appointment of these officers, in the court's view, was constitutional, and challenges from stateside-based finance organizations and then also unions in Puerto Rico to it under the Appointments Clause were not successful. And this was a unanimous 9-0 decision. So a few things interesting about this case as it relates to the Insular Cases and some conversations around them. So one, and again, this is a dynamic that you see repeating itself over and over, when the Department of Justice was litigating these issues in the lower courts, they expressly relied on the Insular Cases as binding precedent for this idea that Congress can essentially do what it wants, and that there are not restrictions, and that the Appointments Clause didn't even apply in Puerto Rico. So carving out this kind of extra constitutional exception and recognizing just the incredibly expansive scope of congressional power in this space. So DOJ and the district court expressly relying on the Insular Cases as well as other parties. So when this case was taken up to the Supreme Court, my organization, the American Civil Liberties Union, Virgin Islands Bar Association, constitutional law scholars, including Christina and others, as well as former federal judges from the territories, all pointed to this and said, you know, look, the Department of Justice, the parties in this case, they've relied on the Insular Cases in making this argument. Now is the opportunity for the Supreme Court to turn the page on this doctrine. And this was an issue that came up at oral argument. So one of the parties in the case, a union, the electrical union in Puerto Rico was represented by a young woman, Jessica Kohlberg-Mendez, who, for her 10 minutes, specifically made the case that the court should take the opportunity to overrule the Insular Cases. And Robert's response to that was, I just don't see the pertinence of the Insular Cases. As Justice Breyer has pointed out, none of the parties rely on them in any way, so wouldn't it be odd for us to address them? She responded, well, no, they actually are relying on them in the district court, DOJ, and even up to the present in briefs before the Supreme Court. But needless to say, she did not make much headway either at oral argument or when the opinion came down. So when the opinion was issued, Justice Breyer specifically addressed this concern and said, we need not consider the request by some of the parties that we overrule the much criticized Insular Cases and their progeny. Those cases did not reach this issue, and whatever their continued validity, we will not extend them in these cases. And then they cited a 1950s Supreme Court, a plurality in a Supreme Court decision, Reed versus Covert, which had said the Insular Cases should not be further extended. And so you have here the court essentially dodging the issue, while at the same time, saying, hey, we're not looking to expand these things. They really should be cabined and narrowed, and not applied to context outside the factual and legal circumstances, oranges being shipped to New York, that kind of thing. The rest of the justices were silent. You had a concurring opinion by Justice Sotomayor that talked about territorial status should not be wielded as a talismanic opt-out of constitutional constraints. And I was like, oh, she's about to talk about the Insular Cases, and then nothing. She was also silent during the 10 minutes of oral argument when the Insular Cases were being hotly debated, even as she was, as is more typical of her, very active during the rest of the argument. So the Insular Cases came up again in another recent case, United States versus Valle Madero. It's been alluded to earlier. It's a case about whether about SSI benefits in Puerto Rico. And the question here was, can Congress arbitrarily exclude U.S. citizens from a national program focused on providing benefits directly to a vulnerable class of low-income, disabled, and elderly citizens simply because they live in a U.S. territory? And there, in an 8-1 decision, the Supreme Court said, yes, because. And that's basically the beginning and ending of the reasoning. They really gave very thin justification for why Congress has the power to do this beyond just an incredibly broad discretion and recognition of federal power to do essentially whatever it wants in U.S. territories. Once again, many amicus parties filed briefs calling on the Supreme Court to use this opportunity to, again, reconsider and overrule the Insular Cases. Virgin Islands Bar Association, Latino Justice, and the Hispanic Federation filed a very compelling brief, as well as half a dozen other briefs from folks in Puerto Rico and elsewhere. So this was, again, a very live issue as the Supreme Court heard oral argument on this case. And once again, you had Chief Justice Roberts trying to kind of narrow the case and move the focus away from the Insular Cases. And so he started out proactively saying, do the Insular Cases have anything to do with this litigation? And he asked that of the Deputy Solicitor General, and the U.S. said, we don't think the court needs to address the Insular Cases here any more than it did in Aurelius, where it noted the court has repeatedly declined to extend the Insular Cases, et cetera. And then Justice Gorsuch came in and said, well, counsel, if that's true, why shouldn't we just admit that the Insular Cases were incorrectly decided? So giving counsel for the United States the opportunity to state what the United States position was on the Insular Cases, to raise whether they thought they should continue to be good law, whether the court should turn the page on them. And he was met with an answer that said, well, those cases aren't properly before the court here, so the court need not address them. Undeterred, Gorsuch made clear, I'm just asking here for the government's position. If the Insular Cases are wrong, and you're proceeding on a premise not inconsistent with them, why shouldn't we just say what everyone knows to be true? So 3 or 4 times, Justice Gorsuch pressed the Department of Justice on this question, which surely they had prepared for leading up to oral argument because multiple parties had raised this in the briefs. And time again, the Department of Justice refused to take a position on whether the Insular Cases remain good law or not, saying simply that the court should not address them in this case. So defending the continuation of the, not just recognizing that they exist or citing them in lower court cases, but actually telling the court that the court should actively not take the opportunity to address them when given the situation. And so this led then to the this decision that has been cited to in Justice Gorsuch's concurring opinion, saying that the Insular Cases deserve no place in our law. Justice Sotomayor wrote a dissenting opinion agreeing with him, saying that the Insular Cases were premised on beliefs both odious and wrong, and that she shared the concurrence's, quote, hope that the court will soon recognize that the Constitution's application should never depend on the misguided framework of the Insular Cases. So a few other interesting things that relate to some of the litigation I've been doing, and Justice Gorsuch's concurrence, as he said, hey, it's time to overrule the Insular Cases, he actually cited to a case of mine that I was litigating coming out of the 10th Circuit, where the 10th Circuit, in a divided opinion, had relied on the Insular Cases to say that people born in so-called unincorporated territories don't have a constitutional right to citizenship. The Department of Justice had expressly relied on the Insular Cases, Downs versus Bidwell, this language that, this really abominable language that Christina had referenced earlier. And you had the Department of Justice, as again, often is the case at the Supreme Court, make an about-face. So while they had relied extensively in the lower courts And some of the briefing, they cited the Insular Cases on half the pages of their brief. Once they got to the Supreme Court, they said, this case is not about the Insular Cases at all. Here's arguments not related to the Insular Cases of why people can be denied citizenship in the territories. Nothing to see here. Court, you don't need to act to, you should not accept the invitation of all of these different parties and amici to reconsider the Insular Cases here. So despite this recognition from Justice Gorsuch and Sotomayor that it's time to turn the page on the Insular Cases, Fidesimano versus United States, and gentleman John Fidesimano from American Samoa, who's denied recognition as a citizen, who continues to be labeled as this non-citizen national status, unable to vote for president, voting representation in Congress, despite the fact that he's lived in Utah now for 20 years, the courts have signed off on saying that this kind of discrimination against people based upon where they live and ultimately based upon their race and skin color, which is the distinction of the unincorporated territories doctrine, is okay. So you have, and again, this Fidesimano case is a good case study in how the Department of Justice has continued to rely on and defend this undemocratic colonial framework, despite letters from New York State Bar Association calling on the Department of Justice to stop relying on and condemn the Insular Cases, despite outreach from civil rights groups like NAACP LDF, ACLU, Latino Justice, the American Bar Association, with the support of the New York State Bar Association, the VI Bar Association, other territorial bar associations, passed a resolution condemning the Insular Cases. There's been resolutions passed by the legislature in the Virgin Islands, the legislature in Guam, all calling on the Supreme Court and the federal government to condemn these cases, and yet still no action. The court has also not taken up a few other cases that presented this. One case in the Virgin Islands, Baxter versus United States, involving whether search and seizure, whether there's an exception to search and seizure under the international border exception. And this is a really odd case because you had the federal court saying yes, or yes, this exception applied in the Virgin Islands. No, it did not, even though there's a Supreme Court saying no, it did not in the context of Puerto Rico. So here you have a bunch of different cases, a lot of questions, kind of what this raises on this 125th anniversary. Will the Biden Department of Justice condemn the Insular Cases? Will it at least stop relying on them in court? Will Congress take any action in this space? Will anyone in the federal government recognize that there is this colonial problem? Will national civil rights and human rights organizations become more involved? And will these issues continue to gain more focus and attention?
Thank you. And thank you very much, Neil. And I just want to mention, if you have questions, note the questions that you have, right? And one thing. And the other is, I don't know if you're hearing we talked about the ambiguity on purpose and the gaslighting, it's a state for this purpose, it's not a state for that purpose, it's, this, it's like this, it's like that, it's heads you win. So you're seeing sort of this pattern, right, in the Insular Cases. And so now we're going to move, though, to some of the practical, what does this actually mean, right? Because it's maddening just to read some of these cases and go through them and try to make sense out of them. But when you think about what some of the practical implications, and we're so pleased to have with us here Professor Emmanuel Hiram Arnault, a scholar, advocate, and expert, to talk about some of the implications in the criminal context and in the benefits context to really give some life to what this means, what these cases mean. Professor.
Thank you. Well, guys, we're almost through. So I know I always get very sleepy in this room, even though it's beautiful. But I will try to keep us continue to be awake here. So I'm so excited to be here with this panel, with all of you, of course. And I'm going to be speaking mainly about criminal adjudication in the U.S. territories. I think that criminal adjudication, or rather the application of federal criminal statutes to the U.S. territories, is really the most violent manifestation of colonial power or colonial rule there. And it really is the most violent manifestation of this thing that some folks refer to as the territorial condition, which was everything that Neil and Christina were just talking about. It's these really amorphous sort of existence in the territories. What can they do? What can't they do? When can they legislate with respect to certain things? When does the federal government tell them that they cannot do? And that too happens in the realm of criminal justice as well, or what I refer to generally as the territorial criminal legal system. For these purposes, I think that the primary role that the insular cases play is what Christina had mentioned in her remarks, which it keeps the territories in this perpetual limbo, not really headed towards statehood, not really headed towards independence, sort of hanging around. They've been doing this for over 100 years, some of them 125 years, and those inequalities that we've been speaking about persist all throughout that time. Now, practically speaking, some of the insular cases were criminal cases. We were talking a little bit about Bajisac versus Puerto Rico. It had to do with jury trial right at the local level. Federal government, or rather the Supreme Court says, doesn't apply based through the Bill of Rights. But that issue actually gets resolved pretty quickly because in Puerto Rico, you can just pass a statute that says that their jury trial does apply in courts. And that's exactly what happens to this day, at least for felonies. Felonies, there is a jury trial right. At the federal level, there's always been a jury trial right because it's federal court. But I'll talk about the juries in a second. Practically speaking, there were other cases, too, that really don't have that many implications as well that came through during the same period and I think are part of the insular cases. You have one case, Hawaii versus Mankichi, which is talking about the provisions of indictment by grand jury and whether that was applicable to Hawaii. Hawaii was an unincorporated territory for a very, very hot second. And then the Supreme Court said, no, actually, based off of certain things, certain markers of progression, citizenship and the such. Now all of a sudden they do have a person has the right to be indicted by a grand jury, and all the other provisions of the Bill of Rights apply. There's also this other case of Ocampo versus the United States in 1914, where it was also talking about the Sixth Amendment jury provision, but in the Philippines, which was also a territory, one of those territories which Christine was alluding to, does get de-annexed. They do receive independence. So it certainly seems to be that is a sort of consequence or practical consequence of the territorial clause. But more broadly, the insular cases just allow other inequalities to persist. And I think that there are some distinct characteristics within the territorial criminal legal system which is worth highlighting, and I'll highlight those for the rest of my time here. One of them is the double jeopardy clause, which Neil mentioned with Sanchez Valle. Another one is criminal jurisdiction for federal jurisdiction and also local jurisdiction. And the third one that I'll talk about is juries, and within juries there's a little interesting nugget that applies just to American Samoa. So I'll start talking about double jeopardy. Double jeopardy, we usually think about it as somebody not being put in risk of another trial after they've been either convicted or acquitted of a trial. So once of charges. Once the case becomes final, you're not supposed to be charged again with the same offense. The problem is, pretty early on in the Republic, the Supreme Court decided that the same offense doesn't mean the same action. What it means is the violation of different laws. And this is why states and federal governments can have successive, dual, and prosecutions. Because if you violate the law of a state, that's under a separate set of laws. And that doesn't qualify as the same offense. That's not exactly the same case for the territories. Pretty early on in one of the other insular cases, Grafton versus the Philippines, the Supreme Court was confronted with this exact question. And in Grafton, it was very interesting for several reasons. One, there was a U.S. service member who is charged with an offense, with murder, and he is prosecuted under the court-martial system. For the court views the court-martial system as being a federal trial, more or less. He's acquitted of killing a Filipino person. The territorial court of the Philippines decides to charge him. They suspect that something was afoot here, and perhaps the trial wasn't as fair as they would like. Lo and behold, they get charged, and Grafton says, you can't do this to me. You can't do this to me because the Philippines is part of the same sovereign. You get all of your rights, and all the power to prosecute from the federal government. The Philippines turns around and says, what are you talking about? They cite to a bunch of cases from other territorial courts, from the territory of Oregon, territory of Ohio, citing to the Supreme Court of previous cases, that in fact territories are separate sovereigns. And when you're separate sovereign, you are just like the states. You get to bring these successive prosecutions or dual prosecutions. One of the other interesting parts of this case is that in the briefing by Grafton, the petitioner here, he actually has a couple pages where he says, let's throw away the legal arguments to the side. Can you just imagine, Supreme Court, that after I was acquitted by court-martial, you're going to allow Filipinos, because there was a majority Filipino court, to sentence me or convict me of this crime? This makes its way into Grafton's opinion as well when the court finally decides that, no, you're right, Grafton. Filipino courts, and as a result, Puerto Rico and Guam at the time, are all part of the same sovereign, meaning you don't have these sort of understanding, or you don't fall under the understanding of double jeopardy. This decision contrasts or is in tension with a decision by the Attorney General preceding the Grafton case, his name was Caleb Cushing, which had reached the exact opposite decision with respect to other territories. So you have this shift that occurs in Grafton that is in line with other double jeopardy cases, mainly coming out of cases dealing with federal Indian law and cases dealing with folks who are trying to sort of circumvent Fugitive Slave Act prosecutions. And this all bubbles up in Grafton. Philippines, Puerto Rico, et cetera, all put in this subservient position. It's a little bit of a tension, though, and I'll discuss it a little bit more with Sanchez Valle in a second, because even though Puerto Rico and the rest of the territories, Philippines and the rest of the territories, aren't treated the same as the states, you're in this odd position where the criminal defendants actually get better, or rather more expansive, broader protections because they can only be prosecuted by one entity, and that's usually the federal government, and as I'll explain in a second. In the 1970s, another case comes out challenging this proposition. This case is coming out of Puerto Rico. As I believe it was Neil who had mentioned that Puerto Rico goes through this, we talk about it as a transformational period where they're granted Commonwealth status. It's not really a transformational period, but everybody makes a big deal about it. Puerto Rico now is somewhere in between territory and statehood. We've sort of popped out of this territorial bucket. We should be treated like a state. And a criminal defendant makes this argument, or rather the prosecutors make this argument in order to bring a successive prosecution against a person, a Puerto Rican person, in federal court. And this is how we get this case of Lopez and Dino. And we can see how the Insular Cases and this territorial condition now are affecting things at a more granular level. We're talking about the Federal District Court, First Circuit. We're also talking about the 10th Circuit, as Neil was talking about earlier. These cases don't bubble up to the Supreme Court. In Lopez and Dino, the First Circuit says, you are right. Puerto Rico has turned itself, and Congress has allowed it to do this. Not that it didn't do it by itself. Congress has allowed it to do this. And it's turned itself something that looks more akin to a state. And as a result, they have now become a dual sovereign. So for several years, from 1978 or so, or 1987 rather, 1987 up into 2016, you had these successive prosecutions, dual prosecutions, only happening in Puerto Rico, not happening in any of the other states. Sanchez Valle comes around and places Puerto Rico and the rest of the territories, as I like to think about it, right in their place. Tells them with really explicit detail who they are, where they get their power from. The court says that in order for you to become a dual sovereign, in order to bring successive prosecutions, we have to look at the ultimate source of prosecutorial power. And reviewing this history that we've heard so far, you can probably tell where that source of power comes from. It doesn't come from the people of Puerto Rico like it does from, or the people of Guam or the people of any of the territories as it does come from the states. It comes directly from the federal government. And until the territories become something else, become a state most likely in these circumstances, they'll never become a dual sovereign. I think that this has several practical implications, one of them being the consolidation or continued consolidation of federal power in the territories. And we see that because the federal prosecutors in the territory tend to bring the sort of more hot-button issues. And they bring the more hot-button issues, those cases that make the cover of the newspaper. They're the ones prosecuting those cases. And in some territories, like the U.S. Virgin Islands, usually what happens is the prosecutor rings up the local prosecutor, the federal prosecutor rings up the local prosecutor and says, how are we going to do this? How are we going to negotiate? Who's going to prosecute? More often than not, if the federal government wants it, they take it. Puts the local prosecutors in a subservient role. In Puerto Rico, because they have this really in-between moment, at least optically, because of this Commonwealth this Commonwealth status, there's a more formal agreement, this memorandum of understanding. And what the memorandum of understanding does is that it funnels all sorts of cases to the federal court. We're talking about cases that generally can just be prosecuted under local codes, carjackings mainly, firearms offenses, the like. And what this does, and I think this is really the most nefarious part of this whole scheme, is that it circumvents some very important procedural protections for folks in Puerto Rico, specifically a right to bail. You have to get a number to post. You will get in all different types of manners, a right to bail that also comes with automatic, with you going out of jail automatically after, I believe it's 90 days, under supervision, of course. So you're able to defend your case better by being outside of prison. You also circumvent a prohibition against wiretapping. This is in the Constitution of Puerto Rico, and all other protections. And federal prosecutors entered into this memorandum of understanding with this idea of circumventing local rules consciously. They knew that this was going to be the effect, and what you have is a significantly higher number now of Puerto Ricans subjected to federal prosecution. Remember, Puerto Ricans who don't have the right to vote, who have never had a say in any of these statutes that they are now being convicted and sentenced under. Finally, I think that this also optically sort of buttresses this mythos of federal power and federal sort of competency in the territories, meaning that the territorial governments are usually seen as incompetent, and the federal government is always going to come and save the day. The next unique aspect, and I'll talk about this one rather quickly, of the of prosecutions in the territories has to do with jurisdiction. Since federal power, quite literally from the Supreme Court's perspective, is king, that means you don't really need to, from the federal prosecutor's perspective, file certain or argue certain issues of jurisdiction. Usually you need a federal hook of some kind in order to bring this case into federal court. But that's not the case under the Mann Act, for example, or under the Hobbs Act. For example, one section of the Mann Act prohibits folks from, or rather authorizes prosecution for the transportation of minors with the idea of committing a sex act with them, as long as it happens in any commonwealth or territory. So you don't need to cross state lines. You don't need to text somebody to make sure it pings off a cell phone tower elsewhere so you can say that this is interstate commerce, as long as these actions happen within the territories, not just Puerto Rico, all territories, because territories and commonwealth, you're going to find yourself in federal court. With the Hobbs Act, same thing happens. If you have, these are robberies that happen usually under fraud and duress. As long as it happens within one of these territories, it goes to federal court. If you were in a state, the federal prosecutors would have to allege some sort of federal hook, and more likely than not, those types of cases that I just described would have found themselves in state court, where in Puerto Rico, you actually do have, I think, a pretty good representation of the community within the penal code, although that's a separate story that I'm happy to explain the history of the penal code in Puerto Rico as well. Finally, there's this problem of juries in all the territories, but specifically in Puerto Rico. There is an English proficiency requirement in order for somebody to serve in federal juries. And you might notice that the vast majority of Puerto Ricans, well, really all Puerto Ricans speak Spanish first, English second, and I would put maybe third or fourth place and nothing in between, because oftentimes you have a very big difference between the proficiency in Spanish, which is the first language, and this very far away second language of English. And as a result, by some calculation, 90% or so of people in Puerto Rico who are eligible to serve on the, or who would have been eligible to serve on the jury are no longer eligible. They're ineligible. 90% of the population is ineligible because of this English proficiency requirement. What that means, practically, is that the juries tend to be very elite, socioeconomically, and very white. And what I mean, the fact that you typically have in Puerto Rico mainly black Puerto Ricans as defendants and now all white Puerto Rican juries, something that looks very similar to some parts of the United States. The last thing I'll say that is related to juries is specifically with respect to American Samoa. American Samoa, there's no district court there, which makes it really hard for folks to have federal cases there. And what the United States has decided is that what we'll do is we'll plug any federal defendants out of Samoa, and we'll take them. They used to be to main justice in D.C., now they take them to the District of Hawaii, and we'll have all proceedings and the jury trial there. As you can see, in neither of these circumstances do you have a jury of your peers. Not only do you not have a jury of your peers, but you're also being punished and prosecuted under laws that you've never had a say in creating or shaping or amending. So that's the practical, I think, and violent manifestations of not just the insular cases, but the territorial conditions on the ground, specifically in the realm of criminal adjudications in the territories.
Thank you. Thank you, Professor. Thank you. And now we have Manuel. Right, and so our next speaker, there he is, I see you there, is Professor Manuel del Valle. We're so pleased you could join us. Can you hear me from Puerto Rico?
Perfectly.
Oh,
perfectly.
wonderful. Where he not only studies, but lives the implications of Puerto Rico's separate and unequal status as a U.S. territory. Again, you have his bio and his extensive work in your material, so I won't belabor the point here because we really do want to hear from you. He's going to talk a little bit more about what the implications are of Puerto Rico's colonial status. So, Professor del Valle, please proceed.
Thank you. We have little time. It's fine. Let's get to the bottom line. What determines the destiny of a people? The people or a territory? Should the land determine the destiny of the people, or the people determine the destiny of the land? Peremptory norm in international law. The Insular Cases say it's the land under Article 4, Section 3, Clause 2, known to all Puerto Ricans as 432. It's where we lost our rights at 432. And it's the argument about Abiso Campos that the Treaty of Paris of 1898 was null ab initio. None of this conversation encompasses the fact that in 1897, Puerto Rico had elected its first parliament, its first prime minister. None of them were consulted on the transfer of Puerto Rico to the United States. GAOR, General Assembly Organization Resolution 1514-XV, also known to Puerto Ricans, says the people in the form of self-determination are entitled to a process of decolonization, and that includes Puerto Rico within the genesis and compass of the United Nations. But let's look at the numbers. America Samoa, 2020 population, 49,710. Poverty rate, 2017, 65%. Guam, population, 153,837. Poverty rate, 22.9%. Northern Mariana Islands, 47,329. Poverty rate, 52.3%. Puerto Rico, 3.194, 3,194,000, 43.1% poverty rate as we speak. Projection for population of Puerto Rico in 2050, 2,500,000. Puerto Rico has been devastated by outmigration. 3 million in Puerto Rico, 5 million in the United States. What this really means, when you go down to it, you look at the number of students in public education, 300,000. 40% are special education, unheard of in the United States. 40%. How do you build a country when that is your future? How do you address that? In the United States, 25% of the population is in public schools, and nowhere near the 40% in terms of special ed, 12%. U.S. Virgin Islands, 80,146, poverty rate 22.4. The Philippines in 1903 had 7.6 million people. That's why you had the Insular Cases. They didn't want 7.6 million to become Americans, period. Puerto Rico is a country that develops in the 1800s, has about 100,000 population. By the 1898, has 898,000, a million. Comes to be in the last half of the 19th century. So when they talk in these cases about alien races or savage tribes, and they put everybody in the same kettle, they're talking about these scenarios. Puerto Rico, right now, 1/4 of the population is over 65. How do you build a future with 40% of your children in special education and 25% of the population retired? 40% of the population in poverty, with the lowest Medicare rates in the United States, and yet we pay into the system the same amount of money. We can talk for days about Valle Madero, but that's a very simple overpayment case. It's an overpayment case. It's a New Yorker case. It's not a Puerto Rico case. It's a New Yorker who came to Puerto Rico, a Puerto Rican, to take care of his family in Loíza. And then the government went after him for $23,000 in overpayment, never told him his rights in Spanish, a requirement of the agency, never told him he had a right to a waiver of any liability because of his poverty. And it winds itself all the way up to the Supreme Court on the question of Puerto Rico and Puerto Rico's entitlement. The problem set that we're talking about is a problem set of poverty and of powerlessness. And the result of that is an exodus of our people, our population, our skilled youth, and a lack of trajectory. Puerto Rico is on a trajectory for decline, as are many of these territories. Because of that, the insular cases become important. Isabela Gonzalez didn't know she was being the first Puerto Rican civil rights pioneer in ensuring that Puerto Ricans could, as American nationals, could travel to the States and not be deported. Why did she want to come to New York? And she had been betrothed to an American and thought they were going to get married. They didn't. But she stayed in New York. She stayed in the States, moved to Jersey, grew up her family in New Jersey, and then had all the rights. That funny little language in Balzac versus People of Puerto Rico, that if Puerto Ricans want the exact equality of Americans, let them come to the United States mainland and there be afforded those rights. Why is that? Why is that still a viable argument in the 21st century? It makes no sense. And yet it is the buffer to the importance of Puerto Rico. What does that mean? An island 100 by 35 miles generates over $108 billion GNP, the 12th largest economy in all of Latin America. Those are the interests that the federal government is pursuing and protecting. Puerto Ricans want a right to vote for the President of the United States, but that would require an amendment to the U.S. Constitution. Some Puerto Ricans, many Puerto Ricans, want a change of status. But where's the plebiscite for that authorized by the UN? Some would want statehood, which is opposed by the Republican Party, though it's in its platform. The essential issue here of insular cases is they're not insular, they're not isolated to a system that does not allow for outcomes of equality. And I think that's where the work that Neil does and everybody else on this panel has done is imperative. Those who do not know these things need to know them. And if Puerto Rico is to survive as a body politic, I would argue 500,000 Puerto Ricans presently in the United States need to return. They need to come back home. That's the challenge that we face going forward. We have lots of issues, we have lots of problems, but we also have lots of possibilities and talent. The talent that you see represented on this panel is incredible. It's only part what's out there. I would argue that the insular cases need to be overruled entirely, but that doesn't change the problem. The day after they are overruled, they'll treat all the territories as incorporated and proceed like they did before. There is a question: is the jury a fundamental right? Because the issue in these cases was fundamental right. So what are our fundamental rights? Ball said we people of Puerto Rico is wrong. In 1922, Puerto Rico had already had 20 years of jury experience totally ignored by the court because it had adopted the Criminal Code of California, 1893, because it was the only bilingual code they found in the United States. So the criminal code in Puerto Rico has been the California criminal code essentially since then. So in 1922, when the court says Puerto Ricans had no experience with jury trials, false. We need to revisit these cases and correct them as well. Factually incorrect. So, joining Gorsuch, these cases are rotten to the core. They talk to a racism and imperialism long past its day. We are in the 21st century, where the peremptory norm is self-determination. That is what should be applying to Puerto Rico. That's what we need to consider. Thank you.
Thank you, Professor Del Valle, for making it real and talking about the implications on the island and in those real terms, in terms of what it means for the people on the island, what it means for the ability to sustain itself on the island, and also the connections between the concern about Puerto Rico and the U.S. territories and the concerns here. And so, I want us to be thinking in terms of those connections, right? And the work of the diaspora and the work of us as lawyers concerned about the rule of law, why it is that we should care about these fundamental issues, because they really go to the heart of, humanity and dignity and equality and, just the self-determination. And I say that, and I'm noticing, I just wanted to give a shout out. We do have some representation from the governor's office here today. Roger Maldonado is here, and I wanted to just recognize, I know we have Nesa Alcina as well, who is here. We also have members of the judiciary, including Judge Walter Rivera. Who am I missing? Oh, wonderful, Nancy Conde, and we'll do that when we transfer to the between the fireside chat. And so here we are. We had wonderful presentations about the insular cases and their background, about the new insular cases, and, you know, the sort of heads I win, tails you lose, ambiguity, you're a state for this, you're not a state for that, you're, right? The implications in the criminal law, and the really serious implications for people living in the territories. And I wanted to transition now to see if folks who have been listening, and you've been such a great audience, if you have questions for our panelists. We're going to open the floor for that. I know I have questions for our panelists, so if you don't do it, I will. Yes. Oh. Yeah, anybody want to comment on that?
So I support Puerto Rican statehood, so I would love to see a deal that brings Puerto Rico in and D.C. as well. But Puerto Ricans have long been very divided, and a very small percentage supports independence, but a larger percentage supports something in between what we've got, but improved. And where that comes from is a sense that Puerto Ricans many Puerto Ricans are sort of, they feel distinct. They don't feel fully American. They feel like it would be a sort of declaration of defeat after being annexed and then denied equality to then petition for statehood. And so they prefer a more arm's length relationship to the United States. I'm not teams. People don't want to give that up. And to link it back to the insular cases, I really don't think that I've written a lot about the insular cases. I don't think they're the cause of everything for sure. But they did set Puerto Rico and the Philippines and Guam on a different path. And that really had profound sort of, psychological consequences. People, didn't think of themselves as on the way to statehood, and that makes it really difficult to build the kind of consensus and support for admission into statehood that everyone on all sides wants to see. And so I think it's because Puerto Rico was put kind of on a different path that Puerto Ricans became divided on the issue, with some saying we should just, keep pushing for statehood, that's where we ought to go, and others saying no, and the federal government, although they're willing to exercise their power in the territories, isn't willing to force it on Puerto Rico. It wants to see overwhelming support for it in Puerto Rico before it proceeds, and so that's where we are. Mm-hmm. Yes, although the United States sort of set the Philippines on a path to independence in 1916 and then postponed granting it until after World War II.
I see another hand.
Sure. Yeah, that's the issue I've been litigating for the last 10 years. And you have the position of the United States, exactly as you characterized it, that people born in so-called unincorporated territories do not have a constitutional protection of citizenship. Congress, of course, can recognize anybody they want all over the world as citizens, but there are precedents that distinguish between what are the protections for citizens that are born or naturalized in the United States. This is a Rogers versus Belay decision, and those who are born or naturalized outside of the United States. And so it's absolutely clear that the position of the federal government and the courts to date that Congress could prospectively deny citizenship to people born in Puerto Rico or any of the unincorporated territories. But there have been a number of amicus briefs filed by leaders from each of the territories expressing the concern that under this precedent of Rogers versus Belay, that Congress could actually do that retroactively. So somebody born in Puerto Rico, lived their whole life as a U.S. citizen, could be denied citizenship statutorily. What Congress gives, Congress can take away. And so that's one of the reasons why folks in each of the territories, not just those in American Samoa who are continuing to be denied recognition as citizens, continue to care about this issue of 14th Amendment birthright citizenship.
Is it okay if I jump in? And so there is some disagreement on that latter point. That is, if you are a citizen under a statute, there's two sources of U.S. citizenship, either the citizenship clause of the 14th Amendment, as Neil was explaining, or a statute. The persons born in the territories have citizenship under statute, and the cases that Neil's been litigating have argued that the 14th Amendment actually applies there, and so the citizenship is guaranteed by the citizenship clause, which I believe is the case. I think that's the best reading of the Constitution, the history. I'm not completely on board. But there is an argument that if you are born a citizen under statute, which is not only persons born in the territories right now, but any American citizen born abroad, you inherit it under American laws that allow parents to transmit their citizenship. That citizenship is itself protected by due process. It can't be taken away on this view. Once you have fulfilled the requirements for achieving statutory citizenship, that citizenship is protected. So there is uncertainty and debate, as with all things territory, which is why it's so important to get clarity on this, as Neil is trying to do. But some people would argue, and I believe in this argument, that if you're already a citizen, it's protected no matter what. Prospectively, Congress could stop granting it in any place where it's not guaranteed by the 14th Amendment.
And that could have implications down the line. I think some people are concerned about that with status change as well.
Of course.
Yeah. Did you want to comment on that at all? Okay. I see a question here. So I've been reminded to repeat the question for the people who are online. So from, what was the period, World War II till, what, II? Sometime in the 70s, the Ryukyu Islands, right, were part of the United States. And he's asking the question, are they now? Do we know?
So I do not believe that any territory occupied or controlled in any way by the United States automatically becomes a territory. So there's international law of occupation and then U.S. law governing post-military engagement that would govern that situation. Those places aren't subject to the territory clause, and Congress doesn't have the same kind of power over them. So the insular case, but let me say something else, actually. The insular cases, your actual question about the insular cases are relevant. I think I just briefly gestured in this direction, but I didn't elaborate on it in my remarks. The insular cases govern the status of these, limbo territories, but they're also relevant in the jurisprudence governing the application of the Constitution abroad. Right. So what really is extraterritorial, the extraterritorial application of the Constitution. So the insular cases govern the question, are one of the cases, are among the cases that govern the question of how and when the Constitution constrains federal action abroad. For example, you will remember the case of Boumediene v. Bush in 2008, which concerned whether habeas applies in Guantanamo, which, despite U.S. control, is not formally subject to U.S. sovereignty and not considered a U.S. territory or part of the United States in any way, but subject to U.S. control. And in that case, the court cited the insular cases, among many other cases and other sources, in that case for the proposition that the provision applied. So the insular cases have this life abroad, which I think is actually part of why the federal government doesn't want them overruled, because of what the implications could be outside of the United States sovereign domain.
If I could add something really fast.
Yes, please.
This reminds me of this is such an important point, because it reminds me not only of the ambiguity that we've been talking about, but also sort of the greater trajectory of the United States imperialism, where the Insular Cases play a part, the post-1898 territories play a part, but you also see a sort of transition away from actually acquiring land and just occupying land, especially through bases, for example. We still, now we have bases everywhere, but especially post-World War II bases in Japan, bases in islands all over the Pacific, sort of getting control of places like the Marshall Islands, things of that nature, some places sort of just ceding or having UN trusteeships, things like that. So that's just sort of tipping the cap to the fact that, yes, the Insular Case is very important, but this plays a role in greater U.S. imperialism too, but there's also sort of this other trajectory of morphing, the United States morphing its imperialism into these other different ways, sort of having these bases, and also having bases in Cuba, which I believe is still there, last time I checked. So, yeah, but that also goes to show that that amorphous sort of nature allows us, allows the United States, the federal government, obviously not a monolith, to not recognize these other territories. It's sort of a bit of a dirty business, but if we keep it or sort of under wraps by continually changing the way we do this, then we can also sort of avert attention from these conversations.
The comment is on Guantanamo. The understanding is that the lease is expired and no one's doing anything about it. Anybody know anything about that?
I don't know, someone else must know, yeah. It's not expired. It's a perpetuity.
So for the people virtually and for the recording, someone in the audience responded that basically the lease is in perpetuity and the Cubans are fighting it virulently. And got it. And the Cubans argue that it's null ab initio because it was enacted under duress. And therefore shouldn't be at all. Any other comments on that?
That's right. The United States had occupied Cuba at this moment, 1898 to 1902. They finally withdrew, and they made it a condition of their withdrawal that Cuba agree to give them land for a base. So it was complete coercion. I'll go ahead and repeat that.
Yes, thank you.
So remember this moment where in the Treaty of Peace with Spain, the United States occupies Cuba, takes sovereignty over the other territories. So that occupation lasts 4 years, and during that period of time, Cubans held a constitutional convention. It's just a fascinating story, including that the military government orders them to have a constitutional convention, which they wanted to be independent. They had been wanting to have a constitutional convention all along, and there's this, the violations are, practical for sure, but also just of dignity, that you would order them to have the constitutional convention that they want to have while you're occupying them when they want you gone. So they do have a constitutional convention, and toward the end of it, the United States enacts a provision of federal law known as the Platt Amendment, an amendment to a federal statute that includes this set of conditions. It's sort of formally worded as conditions imposed on the U.S. military forces before they can withdraw, but they're really they're imposing requirements on Cubans before they'll leave. And there's a list of 7 demands, which include that Cuba accept the United States' right to intervene in Cuba, and that it give it, sell or lease it land for a base, which turns into this lease in perpetuity, and various other requirements. And then the 8th requirement is that they have to take these 7 requirements and put them in the Constitution. So a beyond a violation of dignity that you would, both impose these requirements and insist that they go in the Constitution. And the debates at the Constitutional Convention in 1900 to 1901, just the most fascinating set of debates with Cuban delegates to the convention saying, arguing with each other about whether to accept this or not, and saying, we all know they can invade us. Why do they want us to put it in our Constitution? This isn't what constitutions are for. This is our founding moment, da-da-da-da-da. As you can see, I find this story super fascinating.
As it very much is. It's like, and you think about the hubris that extends in so many different ways. So I've been advised, since my memory is not that good, I can't remember the questions. If you have a question, if you come up to the mic, so I don't have to repeat it, which would be great. But if there aren't other questions now, I still have my question. Where? Oh, sorry, I missed you. Can you come up to the mic? Or would you want me to repeat the question if it's short? It's not going to pick up. I'll repeat it. Go ahead. Keep it. So what I'm hearing you saying is sort of you talk about Alaska and Hawaii having become states, but then you talk about these territories, which are varying size, these current unincorporated territories, and you raised an issue, I think, that is one that has been batted around, right? What does it mean? What does it mean for the structure of the states? What does it mean for representation more broadly in the United States? Can some of the territories qualify, right, as a state? Some are smaller, Puerto Rico's larger, the largest one. I don't know, panelists, do you want to respond to that?
I can jump in on that one. So I'll make a few different points. First, the population of the 5 territories is actually the same as the population of the 5 smallest states. Most of that's in Puerto Rico. So the population of the 5 U.S. territories, 3.6 million, is equal to the population of the 5 smallest U.S. states, who are represented by 10 U.S. senators, 5 representatives, and have 15 electoral college votes. And we don't hear questions, or we most often don't hear concerns about places like North Dakota, Wyoming, and some of these other jurisdictions having a say in the laws that they're required to follow. So that's one point. The second one would be the population of Hawaii and Alaska and many territories that became states is significantly smaller, not just of Puerto Rico, but it's really comparable to even some of the smaller territories. If you Guam and the Northern Mariana Islands together, their population is probably greater than Alaska was when it became a state. But all these questions just come to a bottom line conclusion of, should U.S. citizens who are required to follow federal laws have a say in what those laws are, one, and two, when prosecuted and judged, should they have a say in who those prosecutors are appointed and who those judges that serve life tenure are? And our view at Right to Democracy, and I think probably most people on the panel, think that basic contention of people should have a say in the laws that they're required to follow should be able to find a solution. What that solution looks like, for some it could be statehood, for others it could be perhaps a constitutional amendment, for others independence from the United States, which would address some of those issues. The bottom line, though, is that the United States doesn't recognize that a problem here even exists in the first place. And so until the United States recognizes that this continued denial of democracy and self-determination in the territories is a problem, it's perhaps no surprise that it's continued to last now 125 years with really no end in sight if you look at the most recent actions and inactions by the Supreme Court, Congress, and the President.
If I could add something real fast, I think
Yes, please.
I agree with everything Neil said. The two quick things that I would add is, one, the under or overrepresentation of people per capita. I think that argument with respect to the territories, and certainly with respect to the smaller states, I think just illuminates bigger issues with the Constitution itself, with the Electoral College. For example, senators, representatives, et cetera. That's a kind of a problem that is highlighted by this very question, and I think that that's a good thing. Maybe we should have that conversation. But it's also not the territory's fault that these are the rules that we're playing by, right? So if that's the case, then it shouldn't matter. But I think that the point that Neil has made as well, that I forget, I think it was like 100,000 people needed to be part of the territories.
30,000, yeah.
In order to become a state. So, these territories historically have grown over time, but the bottom line is certainly a democracy issue and also a constitutional issue of sort of figuring out a better way of doing it, but if these are the rules. The real last point that I had was also that these conversations tend to fall on racial lines. These are the same conversations that happened when we were trying to give full representation to the folks in D.C., and you had senators saying, well, we don't want two black and Democratic senators or representatives. They're saying the same thing about Puerto Rico, even though that's not true. They're saying the same thing about the other territories, even though the territories are more sort of purple, if you will, in representation, with a pretty good mix of both Republicans and Democrats. But that's also sort of to highlight the racial implications that are central to everything that we've been talking about today. Well, the short answer, I think, is because it gets railroaded by that very conversation about we don't want two more Democratic representatives, two more Democratic senators, et cetera. That's been the conversation under the Trump administration, was the conversation pretty explicitly. So.
And I think that's a great breaking point for this panel because, and I want to thank all of our panelists for a very illuminating conversation. And one of the questions that I have that brings up, right, is, so it's Congress, right, or it's the executive. Do we give up on the Supreme Court? And I think the other part of that question is, so if that's true, how do we persuade it? What can we do, right? What can we do as lawyers? What can we do as bar associations? How do we contribute to persuading the powers that be? And again, maybe it's the Supreme Court and we keep working on that, I don't know. The executive, Congress, and this special relationship as well that New York has, right, in these issues because of our relationship to many of the territories and the diaspora. And so it's with great pleasure that we now segue over to our fireside chat to discuss those issues with Susan Coleman, the president of the New York City Bar Association, Milna Santiago, co-chair of the New York State Bar Association Task Force on the Territories, Jason Canales, president-elect of the Puerto Rican Bar Association, and with us remotely here, I see you, Anthony Scioli, who is the vice chair of the New York State Bar Association's Task Force on the Territory and past president of the Virgin Islands Bar Association. And as we exit, please welcome the participants in our fireside chat.
Thank you, Natalie. I'm going to go ahead and get started. So as you heard, I am Mirna Santiago, and I am with Natalie, the co-chairs of the Task Force on U.S. Territories. I'm also on the Executive Committee for the New York State Bar Association and am the immediate past chair of the Diversity, Equity, and Inclusion Committee, which is a standing committee at the New York State Bar Association. So I have been very involved in terms of trying to get these issues out to our membership at the New York State Bar, I guess the issue that we've faced, and part of what I'm going to talk about is sort of what we've done, and then my co-panelists will talk about what they've done in their bars and also what we can do, all of us, going forward. So let's start, I guess, with the premise again, of the Insular Cases. And it's basically that each of these cases basically held that people in the territories were from savage tribes and alien races, and that allowing them to have a say in their representation in the government of the United States would actually be a grave detriment to the U.S. That's a quote. This is borne out by the political cartoons of the time that Anthony Scioli always puts up. I don't know if he's going to put them up today, but it shows the territories either as wayward children or even as animals that are being wrangled by Uncle Sam. That was the thought process behind the Insular Cases. It wasn't about proximity, it wasn't about population, it was the fact that 98% of the people who live in the territories were people of color, and they could not be seen to assimilate into the general U.S. population. So when Sherry Levin Wallach, who you heard from earlier, came to me and Natalie and said, you know, how do we get the word out about these cases and the fact that they are based on such racist premises and they're still good law? And our issue at the Bar Association was really apathy, right? That people did not really care. We are a statewide organization. There's not a lot of diversity in parts of the state, and you know, issues that affect Puerto Rico and Guam and you know, the Northern Mariana Islands, American Samoa, just really didn't appeal to the people in other parts of the state. So for us, the challenge was really about how do we make them interested in that topic. So what we did was we started creating programming that linked it to issues that were hot button issues. We had one on voting rights. And, you know, obviously people are very interested in voting rights, especially with a lot of the laws that are being passed. And then we link them to the voting rights issues in the territories. One is, you know, we did one, a demonstration argument on Vallejo Madero. We did a moot court argument of Fitisimanu. We did a symposium called How Can You Lose Your Rights as an American Citizen with Just a Change of Address? And the opening question for that program was really, if you decide that you're going to spend a year in France, you can vote. You can use absentee ballot and vote in federal elections. If you decide that you are going to go live in Puerto Rico for a year, you cannot vote. And people were really interested. They perked up. So that has been, again, the challenge for us. I think we lived up to the challenge. We did resolutions with the American Bar Association where we agreed that we would work together to overcome and have these cases overruled. And then going forward is just about keeping it top of mind. I come from a DEI background, so for me, I know that once you let things slide into sort of the back burner, people forget about them. So it's been about having at least once a year a CLE or a program that talks about these issues so that people are constantly being exposed to them and the new cases that are coming up so that, again, we are all working together to find ways and see how we can get these cases overruled, because I think it's high time that they are.
So thanks so much for having me here tonight. I'm honored to be here on behalf of the Puerto Rican Bar Association. As mentioned earlier, my name is Jason Canales, and I'm president-elect of the Puerto Rican Bar Association. I want to thank all the panelists for a terrific presentation, very informative, very important. I'd also like to thank the State Bars Task Force on U.S. Territories and the City Bars Task Force from Puerto Rico for all of their work over the years and presently. Picking up on what Myrna said, I think one of the issues lies with letting things sort of simmer in a way and not keeping up with it. And I think as bar associations, it's incumbent upon us to keep the dialogue moving forward by both educating, engaging, and activating our memberships to actually get on the ground, start lobbying, start taking on pro bono cases that are going to make a difference in the territories. For most of us, most of the members, or some of the members in our association, we're directly and indirectly impacted by the inequality in Puerto Rico. So I assume it's similar for folks from the other territories as well. What I found most interesting in the presentation tonight were the jarring statistics that Professor Del Valle had mentioned. And I think it's important to recognize those statistics and to take those statistics back to our organizations. He mentioned that 40% of students in Puerto Rico receive special education. A quarter of the population is over 65 years old. 40% of the population is in poverty. There's a mass exodus of people from Puerto Rico. These statistics are important, and when people hear them, they understand what the issues are, and they want to help to make a difference. And so I think it's imperative upon us to get real statistics like that and share them with our groups so that we could continue to move the ball forward to create the change that's necessary.
Anthony, do you want a chance to speak?
Yes, I can jump in now. Thank you very much for, okay, looks like there's an echo when I talk here, but okay, hopefully I'll take care of it. Okay. All right, thank you so much for having me. I was supposed to be here in person originally, but there was an early dismissal at my son's kindergarten at 11:45 a.m. due to the excessive heat. So I was not able to make a trip from Connecticut over to New York City today. So I am really glad that New York City Bar Association will accommodate me on such short notice. Though I do wish I was there with all of you. But I'm going to put on my Virgin Islands hat and not my my NISBA hat for this, because I did serve as past president of Virgin Islands Bar Association. And I want to say that one thing that we have done to try to raise awareness is to make it clear that this is not just a Puerto Rico issue. This is an issue that affects other territories as well. I know Puerto Rico gets a lot of the limelight because their large population, because you had Hurricane Maria, have news. You had President Trump feuding with various leaders in Puerto Rico. You have the whole question of Puerto Rico statehood, the politics of Puerto Rico that on occasion ends up going in the mainstream press. But the Virgin Islands is often forgotten. A lot of times people just forget that we exist. Guam, St. Maarten, American Samoa, perhaps even more so. But even though we're smaller, our issues are the same and also different in many respects. And so one of the things that I've been personally doing is to raise awareness of what affects the Virgin Islands and how that may be different from Puerto Rico. We heard also talk about the new Insular Cases earlier, but it's interesting because the Virgin Islands Bar Association actually supported the decision in Sanchez Valle, did an amicus brief in support of the criminal defendant, because from our perspective, you're giving greater rights to the people in the territories than people in the 50 states through that decision. And so all territories have different perspectives, different views on some of these issues. We've heard a little bit about American Samoa and their views on citizenship. Though I don't believe that the American Samoa Bar necessarily shares the same views as its government. But one of the really key things has been just to raise awareness, make clear that territories are not all the same. We are different. We have a lot in common, and we also have a lot that we do not have in common. There are a lot of areas where we disagree, but also some areas that we agree with, some we disagree with. I will say that it has been really great to forge partnerships with the other bar associations. The Virgin Islands Bar Association has a special relationship with the New York State Bar Association. And in fact, also a couple of weeks ago, we signed a new friendship agreement with the California Bar Association. It's my hope that we will perhaps formalize a relationship with the New York City Bar Association at some point in the future. But really, it has been absolutely amazing to get to know everyone on these issues. As Sharon Gerson said at the territory reception to ABA, New York's from New York's perspective, territories' issues are their issues, but from Virginia's perspective and perspective of other territories, New York's issues are our issues as well. We are still part of the United States. A lot of the issues that affect New Yorkers also affect those in the territories. We heard a lot about Valle Madero, and I believe it was said that that was really a New Yorker issue. You had a person coming from New York to Puerto Rico temporarily to take care of a sick relative, and this New Yorker who was receiving federal benefits all of a sudden had those benefits cut off by a change in address. Not only cut off, but then had to pay back benefits that were received. People often ask me, why should the mainland United States care? Why should we care about Puerto Rico? Why should we care about the Virgin Islands? And to me, it's the same reason you care about why lawyers in the northern states care about Jim Crow in the southern states. It ultimately affects your people. It affects our nation. And again, I don't want to take up too much time here, as I know we're running short here, but I just want to thank you, all of you, for your support, especially those in New York State Bar, the New York City Bar, for putting this on. And I'm more than happy to answer some more stuff in a bit, but I'll turn it over to you. Sorry, it's a bit awkward with this video here. There's a bit of a delay in what I'm seeing and what I'm saying. So,
Great. I don't know, did you want Senator Gillibrand's? What was her name? Nancy, are you still on, hopefully, and would you like to speak very briefly? It looks like maybe not. So did you want to say anything? There's a seat right here for you. Yeah.
Thank you. Hello, can folks hear me okay? Great. Well, it's such an honor to be here for what was truly an incredible panel in a room filled with people who are, from, as was noted at the outset, a really diverse background in terms of where they come from and their familiarity with these issues, but a strong unification in a passion and an interest in the importance of them. Governor Hochul shares that view that this is truly an important issue. She regrets that she wasn't able to attend, but I consider it my honor and privilege to have been able to be here in her stead. And the governor's office really wants to thank the New York City Bar Association and all of the other co-sponsors for this event, as well as the individual panelists and the members of the Fireside Chat, for engaging in this robust conversation on such a critical topic. And we hope that this is the first of many conversations on this issue, because just the fact of talking about it and spreading this awareness is so central to having it be something that we all collectively within the legal profession, but also as citizens of the state, the country, and many of us members of the communities that we're discussing, that we have at the front of our minds. So really want to thank again for this opportunity. The governor was honored to be invited. My pleasure to be here on her behalf. Thank you so much again.
Great. So I think I'll just close out this chat part and certainly echo the thanks to all of the panelists. It was really a great discussion. I think from my perspective, what struck me so much about this evening is how much education is needed of people to understand the problem, which is so complicated. Because yes, it sounds like it's about the insular cases, but that clearly isn't going to solve it all. I agree with you. Those statistics that we heard about each place, I think he said 63% about Samoa, 22.9% Guam, 52.3% the Mariana Islands, 43.1% Puerto Rico, and the special education needs with the aging population. I don't think people even, that's for later. That's not even just the insular cases. But as the president of the city bar in this august room, I feel like, and also I should comment, I think someone made the comment that, here in New York, it hits home for a lot of people, and you speak about the diaspora. I think we can be a place to bring people together and educate people. Our task force with our co-chairs has done a great job. I think all of our bar associations need to link arms and talk about how to help really get this message out. I think, the professors we heard from, maybe there's something we can do with law schools and with the not-for-profits. Those organizations are critical and need our support. So whether it's, more and more of these kinds of symposiums, and we need to figure out ways to amplify the message. Podcasts, education seems absolutely critical here. because it clearly isn't going to go away. So I think with that, I'm going to turn it back over to you guys. But this is definitely just the beginning, and I hope you feel as energized as I do about trying to figure out how to help address the problem.
So as we close the night, very much on time as we expected, thank you so much everyone for showing. We are very happy to have such a distinguished panel, amazing speakers who have made, for me, much more clear the problem. What is the problem? And I happen to be from Puerto Rico. I was raised in Puerto Rico. I was born in Puerto Rico. I was educated in Puerto Rico. And a lot of these issues still sort of are, I'm trying to grasp the history and and what is the real problem. But, I think that the panelists have done a great job. Natalie, you want to come up and...
No, I just want to echo all of those thoughts, and thank you all once again for being here, because it is so important to this endeavor to reach out and to have people, and I know we had a mixed audience, some who are familiar with the issues and want to learn more, others who are just like, wow, I didn't know that was the situation. I didn't know these cases were the way they were. It's so important, and I agree, to educate and raise the issues, because we've got a task ahead of us to really address the issues facing the U.S. territories.
I want to give one recommendation, and that is, talking about how the bars are, one of the questions for the panel, for the fireside chat panel is, what can we do? What can we do as lawyers? What can we do as the public? What can we do? And one of the things, at least as lawyers, that we can do is join the task force. We have a lot of work. We have a lot of work. So we are happy to accept applications. We are accepting applications year round. Carlos, if you want to say, Carlos is my co-chair, and so and Mirna is the co-chair of the State Bar with Professor Natalie Gomez-Velez, and so join the City Bar, join the State Bar, and join our committees, and we will together educate others on this issue.
I have not much more to say than what my dear colleague here says, but yes, definitely, we would like to have more members. There are a bunch of other issues, not only this one, that need to be addressed, and we would like to have more volunteers to help us address some of these issues to the depth that they need to be addressed.
Thank you. I also want to thank the concerned citizens for being here. Thank you so much for your support. And I want to thank the chairs of the various committees of the City Bar who are also co-sponsored this program and have shown support for this issue and for what we're trying to do here. So thank you very much and good night.
Thank you.